deadly blunder? End of the road for Senzo Mchunu for disbanding political killings task team as SAPS Legal boss Major General Petronella van Rooyen nails him at Madlanga Commission. Katmatala's blue lights get EMPD chief in hot soup, begs for immediate special leave as the situation gets tense. What happens when the very people meant to protect us become the ones under suspicion? South Africa is grappling with this critical question as Police Minister Senzo Mchunu faces serious allegations of abuse of power and interference in police operations. Did he make a fatal mistake, a move that could cost him his career, by disbanding the KwaZulu-Natal political killings task team? Major General Petronella van Rooyen's testimony suggests he did, and the potential implications are staggering for the entire nation. Meanwhile, hundreds of kilometers away in Ekurhuleni, Acting Chief Julius Mkhwanazi's questionable relationship with businessman Vusimuzi Katmatala raises even more disturbing questions about who is really in control of law enforcement and whether justice is truly blind in South Africa. As tensions rise, Mkhwanazi has urgently sought special leave, stepping aside amid calls for his suspension and investigations that could unravel more layers of misconduct. These claims suggest that criminal syndicates with ties to politicians, prosecutors, and even judges have infiltrated the top levels of the police service. The commission, led by retired Constitutional Court Justice Mbuyiseni Madlanga alongside advocates Sandile Khumalo and Sesibaloi, is tasked with examining whether Mchunu's orders to disband the task team were lawful, classifying them as directives, policy decisions, or operational intrusions. The outcome holds significant weight, as it could influence Ramaphosa's decisions on Mchunu's cabinet position and clarify the boundaries between ministerial oversight and police operations. Major General Petronella van Rooyen, in her role overseeing governance, legislation, and policy for the police service, has become a pivotal figure in this inquiry. During her appearance on Thursday, the 25th of September 2025, she firmly stated that Mchunu lacked the legal authority to disband the political killings task team. She bases this on Section 207 of the South African Constitution, which grants the National Commissioner exclusive control over managing the police service.
The powers and functions of a Minister of Police in South Africa are primarily defined by the Constitution as discussed above, and in terms of the Police Act. The Minister's role is to provide political oversight and to determine national policing policy, while operational control of a police service is vested in the National Commissioner. The Minister's key powers and functions involve the following. The Minister is responsible to formulate national policing policy in consultation with the provincial governments. This ensures an overall strategic direction of a police. This ensures that the overall strategic direction of a police service is aligned to national priorities in accordance with Section 206 of the Constitution. And in this regard, it should be noted that the Civilian Secretariat for Police Service has drafted various policy documents for approval by the Minister. It includes, for example, a policy on the reduction of barriers in the reporting of sexual offences and domestic violence. Government's policy does not only relate to the decision or view of a president and a minister, and this is even more pertinent in view of our current government of national unity. So it cannot be proposed that even if it was discussed with the president, it has now become government's policy or government's intention to dissolve the PKTT. Clearly it was an instruction by the minister. It also contained the word, I believe repeatedly, direct. The question is, was it a lawful instruction or direction, in the sense that the minister have the power to direct or command the closure of a task team that was investigating crimes. And in my view, it did not have that authority because it relates to the operations, investigating cases and the operations of the police. In other words, the execution of the police's mandate in terms of Section 205(3). If we say the National Commissioner is responsible to manage and control the police service, that must be linked to manage and control the police service in the execution of its constitutional mandate. And the decision of a minister to close a political task team that was responsible for the investigation of crime, in my view, fell outside the mandate or authority of the minister.
So in short, what may be purporting to be a Section 2072 direction cannot be such a direction if it has strayed onto operational matters.
I agree with that submission or with that explanation, Chair.
Van Rooyen argues that disbanding the team falls under operational matters, not policy, and that Mchunu's directive represents an unlawful intrusion into the National Commissioner's domain. She emphasizes that ministers handle broad policy directions, while day-to-day decisions like task team operations remain with police leadership to prevent undue political influence.
Based on the legislative excursus detailed above, I am of a view that the decision to disband the PKTT as a task team lay within the exclusive authority of a National Commissioner, and that the Minister did not have the legislative authority to disband the PKTT, let alone the manner in which he did. I say so for the following 6 reasons, one of which is in the alternative. Firstly, Section 206 of the Constitution enshrines the role of a minister primarily as that of providing policy direction at the national and provincial level. The Minister of Police is not a technocrat. His or her role is to advance the development of legislation and national police policy, particularly in respect of key issues that require executive attention. Therefore, a minister is empowered to select which areas warrant specialized intervention and detention, such as cash in transit, illegal mining, gangsterism, etc. However, a minister cannot prescribe or direct at an operational level, how policy is to be implemented. That is to be left to the National Commissioner, especially in view of the fact that this relates to the distribution and deployment of resources and has financial implications, which falls within the exclusive authority of a National Commissioner as the accounting officer of a Department of Police in terms of Section 36 of the Public Service Management Act. The Minister unlawfully strayed into the constitutional competence of a National Commissioner when he issued a letter for the disbandment of the PKTT. What would have been an appropriate path is for the Minister to express that he no longer considers political killings to be a priority and direct the National Commissioner to consider and take steps to align it with his directive. It can never be appropriate for a minister to instruct the National Commissioner not only to disband the PKTT, but also to say that the disbandment must be done immediately. That constitutes not only an usurping of powers of a National Commissioner, but also undermines the constitutional objects of the SAPS as set out in Section 205(3), especially in respect of ongoing criminal investigations and the potential risk that further crimes may be committed. Thirdly, due to the nature of the offences under investigation, a task team like the PKTT is privy to politically sensitive materials, and its dockets would need to be treated with the same sensitivity. The dockets could not simply be taken back to their respective police stations and investigated in the normal course. I say this because politically related cases are highly organized and are executed through different role players, such as hitmen, spotters, coordinators, and persons who ordered the hits. In addition, they typically involved a conspiracy implicating well-resourced senior politicians.
This testimony aligns with earlier statements from National Police Commissioner General Fanny Masemola and KwaZulu-Natal's Nhlanhla Mkhwanazi, making Van Rooyen the third high-ranking official to accuse Mchunu of overreach. Masemola has described receiving a letter from Mchunu on the 31st of December 2024, directing the immediate disbandment of the task team, claiming it no longer served a purpose in combating crime. Masemola countered this by pointing out that political killings continue to occur far beyond the pre-1994 era that Mchunu reportedly referenced as the only relevant period for such incidents. Van Rooyen builds on this, noting that such a directive not only usurps powers but also undermines the constitutional goals of the police service, potentially allowing crimes to persist unchecked. The implications of Mchunu's actions extend to the handling of specific cases. Following the directive, Deputy National Commissioner Lieutenant General Shadrach Sibiya, now suspended, took steps to deactivate the task team on the 17th of January 2025, despite lacking approval from Masemola. Sibiya withdrew 121 case dockets from the team and relocated them to the police headquarters in Pretoria, where they sat idle for 5 months. Van Rooyen highlights the alarm this raises, as the stagnation of these investigations could lead to lost evidence, faded witness memories, and the continued circulation of items like firearms that might be linked to ongoing crimes. She stresses that any instruction to move these dockets should have come directly from the National Commissioner, not a deputy acting on ministerial orders. Furthermore, she references Section 199 of the Constitution, which prohibits security service members from following manifestly illegal orders, underscoring that Sibiya's actions were problematic from the start.
It is important to highlight that in his letter, the Minister did not direct how the dockets under the task team's control should be dealt with. He did, however, direct that the disbandment ought to be done with immediate effect. I am informed that this determination of the dockets under the task team's control should be dealt on how the dockets to the task team should be dealt with was made by Lieutenant General Sibiya in his letter to Lieutenant General Sintemule, dated 4 February 2025. That letter also makes clear that Lieutenant General Sibiya claims to be acting on the instruction of the Minister of Police to disband the task team. And that letter is also part of my file too. The affidavit, the post...
So can I just ask you maybe...
General, focusing on the prescripts, we know what General Masemola said and what General Mkhwanazi said. Is it consistent with any prescript that you are aware of, whether it's the national instructions or other directives? Is it consistent with any of those for dockets to be taken from a province or a unit or a task team and be stored at national office for a period of up to 5 months without any investigations taking place?
No, Commissioner, it is not. And I think the first reason that raises alarm is it means the investigations are stagnant. Nothing is happening. On that investigation, you would expect the police to proceed as fast as possible and make a breakthrough. But the longer the dockets remain unattended, the more difficult it becomes to investigate that cases properly. Evidence get lost, witnesses forget with time, and therefore the investigation, any investigation, will be detrimentally affected if it is stored somewhere and no attention it doesn't receive attention in the furtherance of the investigation. Based on the legislative excursus detailed above, I am of the view that the decision to disband the PKTT as a task team lay within the exclusive authority of a National Commissioner, and that the Minister did not have the legislative authority to disband the PKTT, let alone the manner in which he did.
Thanks for watching.